first matter to come before the court this morning is State of Ohio versus Antwane Foster. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for a rebuttal. If you are the appellant and wish to reserve any time for rebuttal, let me know when you get started. I'm keeping the clock. You can also reference it on the wall. We've read the briefs. Please do not use the name of minors or victims, as we are going to record and upload this to the court's YouTube channel. Would you like to reserve any time for rebuttal, Mr. Buchanan?
Thank you, Your Honor. May it please the court. Antwane would like to reserve 5 minutes for rebuttal, please.
Certainly.
Thank you, Your Honors. May it please the court. My name is Attorney Wesley Buchanan. I have the privilege of representing Antwane Foster, and as indicated, we're going to reserve 5 minutes for rebuttal. At the outset, Antwane would indicate to the court that as the jury trial, the trier of fact has the ability to resolve any conflicts in testimony and to make what choices they will. Antwane believes that the evidence was insufficient as a matter of law in this regard. He would like to point out, as far as the DNA is concerned, the DNA was not conclusive of any element of force or threat to sustain the charge for rape.
But counsel, that's in any rape trial. The DNA is never going to be, evidence or conclusive as to force. So why is that unique here?
It's important here because between the eyewitness testimony that was not as confident as indicated in the transcripts in the trial, the other thing that in essence pointed to Antwane as a suspect was the DNA on the various, the physical DNA on the alleged victim's person, and then on the window, and then in the room, because I believe there was testimony that there was a handprint, that DNA was there as well. So DNA only leads to the conclusion that someone was there, and then the only testimony believed by the alleged victim that, quote, the contact was unconsensual, I believe was the word testified to at trial. And that was in, I don't have a page number for the transcript. So it's different here as far as the DNA is concerned, because the DNA combined with the lack of confidence interval for the eyewitness leads to circumstantial at best. Now, Antwane understands that circumstantial evidence and direct evidence can be weighed as the same at trial. So that's what at least Antwane would at least point to the court. And again, force is a necessary element for the allegations of rape. Now, as far as the eyewitness testimony is concerned, the alleged victim, if I can use the abbreviation AV so that we are all on the same page, I don't want to confuse anybody, as the court has admonished us not to use various different people's names. As far as AV's testimony was concerned, she was shown a photo lineup, and it was indicated at trial that she had a 70% confidence interval as far as who the alleged attacker was for two different people other than Antwane. When shown the photo lineup for Antwane, she could only indicate that it was a 60% interval, confidence interval. So by the eyewitness testimony, she had testified and given police information that she was 10% less sure about the alleged alleged attacker's identity and everything else like that. The other factors that would lead to the conclusion that the evidence may not be sufficient or the manifest weight of it may not be there would be that the room was dark, it was at night, there were other various factors that were presented at trial that would have led to the conclusion that the eyewitness testimony was unreliable at best. Now, Antwane does understand that this eyewitness testimony was subject to cross at trial, and the trier of fact is free to believe all, some, or none of the testimony presented at trial. So with that being said, the AV testified at trial that it was almost how she entered her window, how she entered the apartment if she would have forgotten her keys would be through the window where the air conditioner was. And she testified to that, and then she also testified that there were roommates that knew that should she lose her keys, that would be something there. And then there was testimony that at least presented and open that the alleged victim and Antwane knew each other prior to this incident. So at least as far as those factors are concerned, that goes to at least the conclusion that maybe the evidence was against the manifest weight, and Antwane should be entitled to a new trial. And again, the contradictory testimony for the lineup. And then at trial, it's the one-person lineup because the only person on trial is the person who is accused. So, you know, in the contradictory statements to the police that she made where she may not have known who this person was only 60% confident that it was Antwane. However, she was 70% confident that there was two other people shown that may or may not have been suspects. So that's very, very important as well. In addition, as far as the jail calls are concerned, as far as Antwane is concerned, Antwane would also acknowledge that no objection was made at trial in regards to the jail call, so this court is confined to a plain error analysis. And Antwane would indicate that as far as the plain error here is that the jail calls did contain inculpatory statements. However, that does not relieve the government's burden of having to authenticate the evidence and everything else like that.
That's what I was wondering, because when I was reading the briefs, I didn't see what the jail calls pertained to. And I obviously assumed they had to be something inculpatory or no objection, but I can't just assume things, I have to know. So what was the jail calls?
Absolutely, Your Honor, and you know, exhibits are part of the record and submitted with the court.
Well, sure, we'll eventually look at the record, right?
And they are part of the record, so we can at least indicate that. Excuse me. Antwane makes inculpatory statements about what had happened that evening. There is a recorded line on the jail call. I think there is a warning as well. However, under Evidence Rule 901, the government still has to authenticate. Even under a plain error standard, how would the trial have turned out as far as plain error standard is concerned if we eliminate inculpatory statements that were reported by Antwane from presenting to the jury? That certainly helps his case. So that would also lead to the conclusion that it would have affected the outcome under the plain error analysis. But again, as far as authentication is concerned, Evidence 901B9, evidence describing a process or system used to produce a result and showing that the process or system produces an accurate result. That being said, the purpose of authentication is to connect particular evidence sought to be introduced to the issues or persons involved in the trial. And that's a staff note to the Evidence Rule 901. Here, there was no testimony as far as how the detective knew it was Antwane, or how the detective was familiar with the jail call process, or why he knew how the jail calls were processed or how they were accurate. And the relevant portion of the transcript that the government asked the questions was in the brief for Antwane. So in this case, the authentication would fail because they didn't establish with a question of, okay, detective, why do you know that these jail calls are accurate? How do you know that they are? Do you know the processes or anything else like that, as Evidence 901 requires? And we would also indicate, at least for the brief, that one of the cases cited by Antwane, State v. Bell, 2019, Ohio 340, and that's on page 22 of Antwane's brief. The 8th District Court of Appeals did affirm a conviction, but they affirmed it because the detective had testified that the detective was sufficiently familiar with the processes involved at the jail, sufficiently knew that it would be an accurate result, and then did comport with the Ohio Rules of Evidence, and specifically Evidence 901. And then in this case, it's the reverse. The detective did not testify at all how that person knew it was Antwane's voice on there, and then how the jail calls were recorded or the processes that were used. So Antwane would at least indicate to the court that because of that, under even a plain error standard, that the admission of the jail call would be prejudicial, jail calls would be prejudicial to his case because of the inculpatory statements made. So while the case cited does affirm a conviction, using the reverse analysis there is that they did affirm the conviction, and the district did right that we do this because the detective did testify about the processes and everything else like that. So with that being said, Antwane would ask this court that to find that the evidence was insufficient as a matter of law and enter a judgment of acquittal, or in the alternative, find that the evidence was against the manifest weight presented and the trier of fact lost its way and order a new trial. And if the court does not have any other questions, I think I'm quickly approaching my rebuttal time, and I will reserve those 5 minutes.
Seeing none, thank you, counsel.
Thank you.
May it please the court, Evan D. Martino on behalf of the appellee of the state of Ohio. We are asking that this court affirm Mr. Foster's convictions for rape, gross sexual imposition, and kidnapping with sexual motivation specifications regarding the victim, whose initials are SA. With regard to the sufficiency and the weight of the evidence, I'd just like to take a minute to point out the evidence that was presented at trial with regard to the facts of this case. The victim in this case testified that on July 25th, 2020, she arrived home at around midnight. She had forgotten her keys and went in through an unlocked window. She went home alone. She went into her bedroom where she was attacked by a man who did not have permission to enter her home, a man she did not know was there, a man that she did not know at all. She said that she initially tried to fight back, but due to the size difference between her and her attacker, she was unsuccessful. She testified that this unknown man molested her, touched her, sexual conduct as well as sexual contact, choked her until she begged him to stop. She testified that he performed oral sex on her without her permission, without her consent. She said that at one point she asked the man if he could at least use a condom, and he said, "You don't want this." When she said no, the man then left. But she specifically testified that she'd never seen him before. She felt a bald head and a beard, which is how she was able to identify him. Identification isn't at issue in this case. Mr. Foster has not disputed that his DNA was found on the victim, on the victim's underwear, and on the handprint on the window, which is ample evidence of the fact that this individual did not enter through the door or with permission. When you couple where the DNA was found with the victim's testimony, it would show that this was not a consensual encounter. She gave consistent version of this event to the sexual assault nurse examiner as well as the detective. She called her mother after the incident, told her mother someone had broken in. There was explanation in the record as to why this victim was a little bit uneasy with calling the police, but she eventually did call the police. There is no dispute that the victim was unable with 100% certainty to identify the attacker, but again, the DNA is there and it points to Mr. Foster. So I'm not sure why we're having this discussion with regard to the certainty of her identification. She never wavered, ever, as to whether she knew this man. She said she did not. So Mr. Foster was trying to put forth a defense that's really not in the record. There was no evidence about it other than through cross-examination. Trying to create this scenario where he had met the victim before at a local pub and that she had taken him home before. She was asked specifically about that. She said, "I don't know anyone named Antwane Foster. I've never been to this particular pub that you're asking me about. He's never had permission to come to my home. I've never taken him back to my house." So there's ample evidence to meet the burden of sufficiency to show that these sexual assaults were without consent, and there is the greater weight of the evidence as well that would support that. When we get to the jail calls, those were authenticated before they were introduced by Rebecca McCutcheon, and that is in the record. I'll get the page number here, but Miss McCutcheon, who works at the jail, authenticated exhibits 40 and 41, which are the jail calls. She testified that they are recorded and kept in the regular course of business by the Summit County Sheriff's Office, and they're contained on the disc that show exhibits 40 and 41, which is in the record on page 501 and 503. After they were already authenticated, then the state used those exhibits during the testimony of the detective, which is why they did not then again ask the detective to authenticate the jail calls, because they had already been authenticated. But they were played, and the record shows on page 550 without objection. You can see through 566. So there is no violation of the rules as far as authentication. So Mr. Foster did not receive ineffective assistance of counsel based on that argument. The second argument that he puts forth for ineffective assistance of counsel is that counsel should have come up with receipts or video surveillance of an event that the victim says never happened. So you cannot be ineffective for failing to produce something that does not exist. So based on the record, the evidence that was presented by the victim, which was consistent with what she reported on the evening of the attack to the sexual assault nurse as well as the detective, and the fact that while her identification may have been less than 100% certainty, she consistently identified the attacker, who she could not see in the dark, as being a bald man with a beard, and she never wavered on her testimony or her assertions that she did not know Mr. Foster. She did not give him permission to enter her home, and she did not give him permission to commit the acts of rape, burglary, gross sexual imposition, or kidnapping with a sexual motivation. The state would ask this court to affirm Mr. Foster's convictions with regard to the victim essay.
Thank you.
Thank you, Your Honors.
Thank you, Your Honors. May it please the court. Again, Antwane would reiterate to the court that given the evidence at his trial and the arguments that he's made in his brief, that the evidence was insufficient and against the manifest weight. And unless the court has any other questions for Antwane or his counsel, Antwane would rest on the briefs and thank the court for its time.
Thank you.
Thank you, Your Honors.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.